Are you Brian Elliott?
Yeah.
Good morning. This is 19 CR 00123 Commonwealth of Kentucky versus Brian Elliott. Mr. Elliott, were you born in 1976?
Yes.
Last four digits social security number 1403.
Correct. Yes.
This is a pretrial diversion revocation. Is that correct?
Yes, sir.
I mean, this is a 19 case, I guess.
It's been going around a while.
Yeah. What do you got
He's
here?
had, in lieu of, I think, revocations. He was at Owensboro Regional.
Speak up just a little.
He was at the Owensboro Regional Recovery. He was discharged for various reasons and didn't report and had a positive drug test. And so we're asking for revocation.
Your Honor, we would stipulate to the violations at this time. We would just ask for the court to allow him one more chance to remain on his pretrial diversion and allow us to arrange a new long-term treatment program for him.
Well, I don't know anything about the case, so I'm not going to make it. If you stipulate to the charges, come around here again. What were the charges?
Well, he was at Owensboro Regional Recovery on, he was discharged on 12/23/25 because he violated their building curfew, failed to report for job duty, which was cleaning. He was eavesdropping on some other clients, and then he tested positive for hydroxybupropion, which I had to look up, which is the scientific name for Wellbutrin. So, and he was discharged for those reasons. And I don't think he reported to Mr. Collins that he after he was discharged.
He was being supervised by Officer Everly.
Oh, Everly. And I could ask Officer Everly if he reported after that. I don't know if he did.
Officer Everly?
Yeah, Jason Everly.
Jason, are you on there? Will you raise your right hand, please? Swear the testimony you're about to give is the truth, the whole truth, nothing but the truth.
I do.
Okay. You may inquire for the Commonwealth.
Officer Everly, how long have you been supervising Mr. Elliott?
He had initially made it to OR September 24th, 2025. So it was about 3 months.
You were only supervising him because he was referred over to Owensboro Regional.
That is correct.
That's correct. When he was discharged from there, did he report to you?
He did not. He alleged that he had to go to the hospital. He was told to report immediately to Barron County Probation and Parole. He didn't end up doing that. He eventually had went back home to wherever it is that he was from. And I think that was Laurel County. And then I spoke with his dad and told him to report immediately to the Laurel County Probation and Parole Office. And he ended up going at that point, and then he was taken into custody per the directive of Judge Wiggins.
Okay, I have no other question.
Would you like to inquire this officer?
Officer Everly, just to be, just so that I'm clear, after he was discharged from the program, so it looked like he had been discharged on 12/23. Is that correct?
That is correct.
Okay. And he was told there before he reported to the Laurel County Probation Office that he needed to report there?
No, it was he was advised 7:30 that morning. I was told when this is because it happened before we had opened. Owensboro Regional Recovery staff advised him to report immediately to Barron County Probation and Parole.
Okay. And he did not report to the Barron County Probation and Parole?
That is correct.
Okay. Was there any reason given why he did not report at that time?
He was saying that he was sick and wasn't able to go. He went home. I made contact with his dad the next morning. They were asking for him to stay with them during the Christmas weekend and then have him report on Monday. I told him that was not the case. He needed to report immediately to probation and parole because he was already back in Laurel County. He was directed to report to the Laurel County Probation and Parole Office, or I directed the dad to have him report there. And the dad got him out of bed and took him to that office.
Okay, so he did report immediately to the Laurel County Probation Office?
After my conversation with him.
Okay. All right, I have no other
What was
questions.
the original? He entered a plea in September 2020. What was it?
I think it was a possession. It's just one of these that's drug on forever where there's been so many violations and things.
A trafficking admitted down to a possession.
That's correct. So I just think he needs to be revoked, sentenced. He's had every opportunity to try to get out of this stuff, but it's been.
If I sentenced him, he could still be he'd be up for shock.
That's correct.
Okay, well, I'm gonna go ahead and revoke, and I want you to get a plan together
Yes, sir.
and send it to the Commonwealth. Mr. Elliott, I don't necessarily want to have you to serve your entire time out. I'm gonna go ahead and revoke you because of the evidence, but your attorney will be over to talk to you to see if we can look at a shock probation as soon as you're eligible for it, to see if there can be a plan, give you an opportunity to reform. Doesn't look hopeful, but I don't give up on anybody, and I'm not gonna give up on you, so you work with it. Okay?
All right.
Thank
All
you.
right.
Thank
Thank
you.
you.
What?
Stevenson.
Commonwealth versus Brian Hunter, 24 CR 004. Are you Brian Hunter?
Yes, sir.
Good morning. Year of birth 1992.
Yes, sir.
Last four digits of your social security number 3209. You're here on shock probation revocation. What does the Commonwealth have to say?
Your Honor, he has a 3-year sentence on possession of a controlled substance first. And we brought this motion because on December 26th of 2025, he allegedly assaulted Kayla Hunter.
Your Honor, we are going to stipulate to the fact that Mr. Hunter has acquired a new charge for the assault fourth. We would just ask for the court to take into consideration that he has not been convicted of that charge at this time and allow him to remain on supervision at least until there is a conviction or an acquittal on that charge. If he is convicted in the future, it is always possible for the Commonwealth to refile.
I think that that's the most hedged stipulation I've ever heard in my life. He's going to stipulate or he's not. And if he's not going to stipulate, she's here. She doesn't want to testify, but she's prepared to. But if he wants to put her through that, we can have a hearing.
No, I'm fine with being, with the revocation. I'll take my time.
Okay. He stipulates, so we will revoke the shock probation. Okay. In other order. Thank you very much, sir. Mark Hunter. The victim's advocate can tell her that she can leave now, or someone can tell her. Ma'am, you're excused. Are you Mark Hunter?
Yes, sir.
This is 19 CR 00114, 22 CR 0053, 25 CR 0032, and 25 CR 0079. The last charge is for an arraignment. Mr. Hunter, were you born in 1977?
Yes, sir.
Last four digits of social security number 8597.
Yes, sir.
You have a right to remain silent. The grand jury of Monroe County has returned an indictment charging you with sexual abuse, first degree vulnerable victim. You understand what that charge is?
Yes, sir.
Okay. You acknowledge the identity of your client, receive the indictment, waive formal reading and arraignment, enter plea not guilty, reserving all pretrial motions.
Yes, Your Honor.
Schedule this for negotiation day on the 6th. 6th of February, and the next court date on the 19th. I'm signing a reciprocal discovery order, sir. Require the Commonwealth to provide information to help you prepare for your defense. Okay?
All right, thank you.
Are you continuing all the other cases?
The cases all will be continued till that date, and all of them included in the negotiation.
Yes.
Commonwealth versus Timothy Jackson. Good morning. Are you Timothy Jackson?
Yes, sir.
born in 1984.
Yes, sir.
Last four digits, social security number 9460. You're here
Yes,
today. Have you had opportunity to look at these two pre-sentence investigation reports done by probation and parole?
Yes, sir.
Well, this is substantially correct.
Yes, sir.
Okay, there are two of them, so I'm going to have to read them separately, but they'll be in the judgment. Upon a plea of guilty of possession of handgun by a convicted felon and persistent felony offender first degree, the defendant received 20 years to serve. The defendant understands that this agreement, he will serve 10 years before being eligible for parole. Upon a plea of guilty to fleeing and evading in 25 CR 0048, he shall receive 5 years. Upon plea of guilty failure of a non-owner or operator to maintain insurances, shall receive a fine of $500. The 5-year sentence in Monroe Circuit Court fleeing of aim shall run concurrent with a 20-year sentence, possession of handgun for a total of 20 years. Upon plea of guilty of assault, second, defendant shall receive a sentence of 5 years in 0031. The 5-year sentence in 0031 and the 5-year sentence in Cumberland Circuit Court 25 CR 0060 shall run concurrent with a 20-year sentence in Monroe County for a total of 20 years to serve. Now we also have Cumberland Circuit Court meeting here by agreement. Is that correct?
Yes, sir.
Upon a plea of guilty to theft unlawful taking less than 10,000, the sentence of 5 years. 5 years shall run concurrently with Monroe Circuit Court case number 25 CR 0048 for 20 years. Is that correct? Defendant shall pay restitution to the victim. Now restitution will be determined by the court at a subsequent hearing.
Yeah, I don't know if Mr. Jackson's going to agree or not, but we researched the pickup. And according to Kelly Blue Book, it was worth $5,100 if sold privately and $5,900 trade-in. I propose to put $5,500 in there. It's just a compromise.
Your Honor, I just spoke with Mr. Stockton about that this morning. I've not been able to discuss it with Mr. Jackson. If I could just have some time to discuss it with him, if we can reach an agreement on that, we can just submit an agreed order on it.
Okay, well, what I'm going to do is I'm going to enter an order for $5,500, subject to you being able to review it with your client and have a portion of that set aside.
Yes,
Okay. Okay, thank you very much. Jacob Keith. I'm waiving the court costs in that last case. Waiving the court costs. Commonwealth versus Jacob Keith, 25 CR 0078. Are you Jacob Keith?
Yes, sir.
Good morning. This 25 CR 0078. Were you born in 1984?
Yes, sir.
Last four digits of your social security number are 4943.
Yes, sir.
Okay, you're here for the purpose of arraignment. You have an attorney here, Mr. Bell. You have a right to remain silent. The grand jury of Monroe County has returned an indictment charging you with sexual abuse first degree to a vulnerable victim. You understand what that charge is?
Yes, sir.
Okay. Mr. Bell, you acknowledge the identity of your client, receive the indictment, waive formal reading and arraignment, interplea of not guilty, reserving all pre-trial motions.
Yes, Your Honor.
Set a negotiation date on this for February the 6th, next court date on February 19th. I'm signing the reciprocal discovery order, which requires the Commonwealth to provide your attorney certain information to help you prepare for your defense.
Yes, sir, Judge. Judge, if we may, I know that he's got a $10,000 cash bond. We're not asking to amend the bond as far as lowering it or anything, but we would pursuant to 431-535, ask that the court make that double property, which would be 10,000 cash or 20,000 property.
Well, I don't know anything about the case, so obviously, so you need to talk to the Commonwealth about an amended order or anything like that, unless you want a bond hearing.
Well, Judge, I mean, per statute, it's my position that you can make it with stock bonds or double property. We're not asking to lower or change the bond. We're just asking for a different way to make that bond, which It's provided in the statutory language.
You don't think I can set a cash bond only? If I set a cash bond, you think that they can make any of them with property?
Well, Judge, if I say you can't, you would, and I'm not gonna do that, but I mean, I know you can, but I'm just saying statutorily under.
Well, I don't want to violate the statute. Are you telling me that statute prohibits me from doing a cash bond?
Well, it's my position that it doesn't prohibit a cash, but it prohibits that being cash only. There has to be other
So
means.
you're
of
saying
money.
that it would prohibit me from doing a cash only bond?
If it's requested that it be made double the property or stocks
Well,
or things of that nature.
I'm not aware of that.
I've had circuit judges to interpret that way in the past.
Yeah. Well, this one hadn't interpreted, but I'm still educable. If you can convince me if you convince me that's what the statute says, I wouldn't intentionally not follow the
I
statute.
know you wouldn't, Judge. It just says any person who has been permitted to execute a bail bond may secure such bond by deposit of cash or stocks and bonds having an unencumbered market value not less than the amount of the bail bond, or by real estate with unencumbered equity at least double the amount of the bail bond. And then it just goes on through that. So
But, yeah,
it doesn't say shall, but it does say may. So that
well,
would be the
that's
stretch.
what I always understood. So it's not same as a clerk approved surety. It's not a surety bond.
But we're wanting double the property.
I understand that.
Yes, sir.
But it's not a surety bond, so it would be, you're asking a property. The other thing would be personal property, right? Read that statute again, read it again.
It only bails, bonds, or, under 431-535, it provides any person who has been permitted to execute a bail bond, which he has with the $10,000, may secure such bond by deposit of cash or stocks and bonds having an unencumbered market value not less than the amount of the bail bond, or by real estate with an unencumbered equity at least double the amount of the bail bond.
Yeah.
Then that's all we're asking for.
You don't have stocks and bonds that you want to put up?
No, sir. I just got some property I'd like to be able to him to put up, which is 20,000 property, which is equivalent to.
Unencumbered.
Yes, sir.
You have any objection to that?
Well, I would ask, I didn't realize, going back looking through his criminal history, that I may have made a mistake in 2010 when I amended a previous sexual abuse down to an assault fourth. So this is not his first time he's been indicted on sexual abuse. So if he is let out on that, I would ask for an ankle monitor or whatever, some stringent conditions.
We would agree to anything like that, Judge. The only thing I asked is be able to work. He's got a business and he's got a very good job that he's making good money at. He just don't want to lose it. He's in jeopardy of losing that. As long as he can work, we don't care if he stays at home all the time.
What are the allegations in this charge?
I want to read it, so I'll make sure I'm correct. He allegedly walked into a room, shook a couch, woke up an 11-year-old girl, counted down from 3, 2, 1, told her to open her eyes, and he was masturbating in front of her. Now, that's the allegations with the child made. And Mr. Bell will need to tender an agreed order so he can watch the advocacy center tape.
I don't know anything about the case, Judge, whatsoever. I went and seen my client at the jail last night, talked to him, and but whatever the charges or allegations at this time, he's presumed innocent until proven guilty. He's been given.
Everybody that comes in my court is
Yes,
presumed
sir.
innocent, and a lot of them are held on no bond because of aberrant behavior or certainty behavior. That's why we have bond hearings.
But we've been given a 10,000 cash, and we're
I
not.
understand that. Now you give me, I'm having no more about it than I did when I set the $10,000 cash, and I might not have set the 10,000 if I'd known so much. See, because I can't call a Commonwealth attorney and ask them about it. That's an ex parte communication. Nor can I call you and talk to you about it.
Well,
So
you
now
call
that I
me,
know the nature of this charge and what the allegations are, I want some additional protective measures in the bond. Stay away from the victim. Is the victim a member of his household? I don't know.
I don't know if he doesn't have any minor children. I wouldn't expect him to be around any minor children under those circumstances.
Well, I don't know what this person, whose household it was, whether we should have him vacate the premises where he is. I mean, I just want y'all to reach an agreement on this, and I will, I'll take a look at letting him secure it with property or something like that. But Mr. Stockton, I want you to talk to defense counsel, make sure that we protect any potential victim, or whether or not it actually happened, the fact that the allegation was made sometimes puts somebody in danger. So I will look at an agreed order if you'll look at that, okay?
Yes, sir,
Thank
Judge.
you very much. Courtney Mabry.
It doesn't matter.
What we just witnessed across these 3 courtroom cases is a powerful snapshot of how the justice system deals with second chances, broken trust, and serious allegations, and how quickly everything can change when a judge decides enough is enough. In the first case, Brian Elliott, we saw a classic example of someone being given opportunity after opportunity. He was placed in a recovery program instead of jail, which in itself is a massive break. The court clearly wanted rehabilitation over punishment. But what ultimately sank him wasn't just the failed drug test. It was the pattern of behavior, getting discharged from treatment, not reporting to probation, and offering excuses instead of accountability. The judge made it very clear here. You don't get revoked for struggling, you get revoked for not being honest and not following the rules. And even then, the judge still left the door open for shock probation, which shows the system isn't trying to crush people, it's trying to see who's actually willing to change. Then we move to Brian Hunter, and this is where things get tense fast. He's already on shock probation, already serving time for drug charges, and now he's facing a brand new assault allegation involving Kayla Hunter. His attorney tried to play a very careful legal game, basically saying, yes, there's a new charge, but no conviction yet, so let him stay free. But the judge wasn't buying the hedge. The moment the victim was mentioned as being present and ready to testify, the entire energy shifted, and when Brian Hunter finally said he was fine with the revocation, that was the real moment of truth. The judge didn't hesitate. Shock probation was revoked. This case shows something critical. Being charged with a new violent offense while already on probation is almost always a death sentence for your freedom, even if you haven't been convicted yet. And finally, the most disturbing case of all, Jacob Keith. This wasn't a sentencing. This wasn't even a trial. This was just a bond hearing. And yet the allegation alone was enough to make the entire courtroom go silent. An 11-year-old child. Allegations of waking her up and performing a sexual act in front of her. The judge's tone changed instantly, from procedural to protective. What's important here is the legal balance the judge tried to maintain. On one hand, presumed innocent until proven guilty. On the other hand, the absolute duty to protect potential victims. That's why you saw the discussion shift to bond conditions, ankle monitors, and restrictions around children. The court wasn't deciding guilt yet, but it was absolutely deciding risk. And that's the real theme across all 3 of these cases, not guilt, not innocence, risk and responsibility. Brian Elliott was a risk because he couldn't follow the structure meant to help him. Brian Hunter was a risk because of a fresh, violent allegation while already on probation. Jacob Keith was a risk because the accusation involved a vulnerable child. In every single case, the judge sent the same message in different ways. The system will give you chances, but it will not gamble with public safety. This is what real courtroom justice looks like. It's not dramatic speeches. It's not yelling. It's calm, methodical decisions that quietly change people's lives, sometimes forever. And now I want to ask you, which of these 3 cases shocked you the most? Was it the rehab failure, the assault while on probation, or the child abuse allegation that changed everything in seconds? Drop your thoughts in the comments, because these are the kinds of cases that spark real conversations about rehabilitation versus punishment, and where the line should actually be drawn.